This is the junior teacher matter. And if my lords are graciously pleased to take appeal number 712.
Which page?
22nd of August 2023, madam.
Yes.
Your Lordship may see the very first slide, subject guideline for engagement of junior teacher schematic. My lords have it. And then the right for children to free and compulsory education act 2009 came into force with so and so. In accordance with the provisions of section 38, no, that's, I leave it at that. My lords may kindly turn to 78, page 78.
Yes.
This is the selection process. My lord sees, my lords, 8.1 talks about a master list, and 8.2 is very important from my perspective. My lords have 8.2. An online computer-based test will be conducted by OSEPA, an authorized agency, as per the syllabus contained in the advertisement, to be published before the recruitment. So there will be, minutes, a test for determining the merit of the applicants who apply for the said post. That's the submission. Your Lordship now sees 8.3. 8.2 therefore contemplates how the examination will be made, and 8.3 says, in my humble submission, once you have the merit list, how will you distribute it within the districts? Now, if I read it slowly, minutes, district-wise and category-wise, draft merit list will be prepared by OSEPA. Draft merit list will be prepared taking into consideration all district preferences submitted by an individual candidate in order of preference followed by merit rank. So therefore, merit is also one of the components to be considered even under 8.3. That is, for a particular district, after exhausting all candidates having first preference, subsequent preference will be considered. In case of time, we are not on time. Now, kindly see, minutes, one more page, and that your Lordship will get at page 85.
There is only one thing which is lacking in this.
I'm grateful.
That the merit list shall be prepared on the basis of test held under 8.2.
My lord, 8.3 does not say that, but 8.2 says that.
8 says that there shall be a test.
I'm grateful.
But what should be the criteria for preparation of merit list?
Correct.
That is not there.
I bow down, minutes. But 8.3 also refers to a merit list. May I read it again, minutes? May I read it again? District-wise, category-wise, draft merit list will be published. So there is a merit is there. Even over the page, merit is there. Now let us see, minutes, one more important page. Your Lordship may kindly turn to page 85. What happens after this is issued? My Lordship's have minutes.
Yes.
This is 10th of September 2023. It is for the information of all concerned that in pursuance of School and Mass Education Department, Odisha resolution dated so-and-so, letter dated so-and-so, 20,000 junior teacher schematic posts will be filled up in the primary and upper primary school under different revenue districts of Odisha. The information of district-wise, category-wise posts will be available in OSEPA website. So-and-so. Applications are invited from intending candidates to apply for the post of junior teacher schematic through online mode only from 13th of September 2023. The last date of submission of online application form is 10/10/2023. No other mode of application will be accepted. There will be no examination fees. Now, next line is very important. The candidates will be selected on the basis of marks secured on computer-based test, CBT computer-based test examination The syllabus of the CBDT is available in the OPSEPA website, the date and time, etc. I am relying heavily on this line. The candidates will be selected on the basis of marks secured in the CBT. My lord, none of the petitioners who are before your lordships challenged this, participated in the examination, and in my humble submission, my lords, they are now stopped from saying that the marks of the CBT have no relevance with their selection. Now your lordship may kindly see, my lord, I will not take much time. Your lordship may kindly come to page 106. My lord Simon. My lord, the writ petition had 4 petitioners. Had 4 petitions. And kindly see, my lord, what was the position taken by us? And Chintamani Bhuya had applied for category 1 science and category 2 science. Just as an illustration to show your lordship. So this was petition number 1. He is a person from Cuttack. He had applied category 1 science and category 2 science. Now, my lord, Chintamani Bhuya has given first preference to Nabrangpur, and there are also 29 other districts preferences available to him. His social category is SCBC and gender, male. His total score is 147.482. Your lordship may kindly note that score. The last candidate of SCBC open means male and female taken together, category in Nabrangpur district has secured a score of 167, which is more than the petitioner. Lord, am I clear, minutes?
Yes.
Now let me see what is his position vis-a-vis the state list. So therefore, his mark is 147.48. Nabrangpur, the last mark is 167. And let us see where he figures in the state list. The score of the last candidate SCBC open category, science, in the state is 166.453. Am I clear, minutes?
Yes.
He therefore does not fit into any place in the state because he has scored 147.48. Nabrangpur last mark is 167. In the state, it is 166.45.
Yes.
Now let me see, my lord, how does he fare in category 2 science? Because he has applied for both the streams. Now if your lordship sees B minutes, Chintamani Bhuya has also applied for category 2 science, and he has given his first preference to Malkangiri. Kindly see a person from Cuttack. For one stream, he says, give me Nabrangpur. For another stream, he says, give me Malkangiri, and let us see how he fares there. Lord, may I place it?
Yes.
Category 2 science has given first preference of Malkangiri, and there are also 29 other district preferences available for him. His social category is SCB gender male. His total score is 150. The last candidate of SCBC open category in Malkangiri district has secured 171.
Yes.
And my lord, the score of the last candidate of SCBC open category in category 2 science in the state is also 171.50. So not only does he qualify for what he had applied for, he does not fit into any other place in the state also, based on his marks. And there are Jittu Nayak, I need not read them, they are all the same. Now, my lords, It is nobody's case that we were a part of the list which was prepared post CBT and we have not been considered. Right. Pages. Page is Nabarangpur. Nabarangpur Melon.
Yes.
Kindly see page 1. It has 21 numbers, page 1.
Yes.
Page 1, if your lordship sees, there are 21 candidates because Nabarangpur had 21 vacancies. Now the last one is 16.315, which your lordship just saw in that affidavit, and his score was 147. Now, if my lords kindly, and your lordship may see, my lords, in this list, at serial number 18, there is one Keonjhar. Right, my lords? There is one, the judgment. If I take all Nabarangpur, which is what I was told to do, to take it district-wise, irrespective of the mark. Here also, if your lordship sees, my lords, post-judgment, the last candidate secures 160.118. This is page 2. The last person in this list of Nabarangpur is 160.118. Now, two things happen.
So this is post-judgment.
Grateful. Now, two things happen here. It drops from 167 to 160. Your lordships had seen the previous page. The last candidate on merit had 167.325 marks. And here it is now dropping to 160, and here also he doesn't qualify.
No, but why this was there? Keonjhar and Mayurbhanj?
Mayurbhanj and Keonjhar, they came because they were qualifying on the basis of merit. Am I clear, minutes? Because on merit they came into it.
They did not qualify their first preference.
They did not qualify their preference, but because of the marks they came here. Second preference was this place. Now the petitioner in the first one, he didn't even qualify because his mark was only 147. If your lordship looks at the next chart, which is based on only district preferences, as directed by the learned single judge.
So this can be a situation.
Yes, parents.
Where this person, Keonjhar,
yes, parents.
He was not getting his position in Keonjhar.
So he came here.
His first preference.
I'm grateful.
But because of his merit position, he was qualifying as per his second.
Because he gave 29 districts, all 30. So he came here. Now, when I do the next exercise, post-judgment, only on the basis of districts, forget merit. Kindly see, my lord, same 21 posts, all Nabarangpur. The first one is, my lord, let me go a little slow. Serial number is 1 to 21, same. Extreme left-hand side column, my lord. And then kindly see, my lord, application number, roll number, name of the candidate, father's name, etc., my lord. And kindly see the last column, marks in CBT. Now, district preference, first preference district. So now we are not going by the CBT. We are restricting it to districts. If your lordship sees that, the last person, serial number 21, he secures 160 marks. So therefore, if I were to take all district preferences, then 160 he doesn't fit in because he has got 147.48. So therefore, my lord, the consequence is this. People from other districts who are more qualified now go out of the list, and in any case, the petitioner does not fit in. I'll take your lordships to one more chart, and that your lordships will see. He also applied for Malkangiri, as I read to your lordships. Kindly see, my lord, page 3. Malkangiri, page 3, originally, my lords, the last cutoff mark is 171.500. That your lordships will get at page 3. And that will be, my lords, serial number 16.
Yes.
And my lord, your lordship will see 17 and 18 are persons with disabilities. So therefore, the last SCB mark was 171.500 and the petitioner had scored 150 marks. 150.5. So therefore, he does not get into this also. Now kindly turn over the page, please. Here now we are saying
for Malkangiri,
yes, my lord.
there was only one candidate
Yes, my lord.
whose first preference was Malkangiri
And who got? Grateful. I'm grateful. Now kindly turn over the page. We go for all Malkangiri. Now post judgment, I don't go by what marks you have secured. I will first give all first preference Malkangiri. Now, my lord, here what happens, your lordship may see the previous page, the last mark was 171.500. Am I clear, my lords?
Yes.
Kindly turn over the page. Post judgment, the last mark goes to 144.617.
167.
I'm sorry, I'm grateful. My lord. 167, which is a drop of almost 27 marks. And the petitioner has secured 150.5. So your lordships will ask me, my lord, then why is not there in the second list? Because he has gotten UR. Kindly see, my lords. The UR list is at page 5. Page 5. And kindly see, my lords, page 8. Item serial number 79 at page 9. The cutoff is 175.904. My lordships have it. Last but one. This is the UR list for Malkangiri. His position is 79 and the cutoff mark is 175.904. Am I clear, minutes?
Yes.
Kindly now see what is the UR list post judgment. Post judgment. And if that list starts at page 9 and kindly turn to, my lords, page 13. Serial number 70.
Yes.
Now the petitioner is at page serial number 70. His mark is 150.5. This is post judgment. And if my lords are kindly pleased to turn over the page, my lords, page 14, the last mark of UAE. So, my lord, it now drops from 175 to 147. 28 marks. And that is how he gets it. The submission to your lordship is this. Are the children not entitled
No, that is not the question.
Yes, madam. I'm
General, the question is,
yes, madam.
There can be two types of selection.
Correct. No difficulty.
One district-wise and the other combined. So if in the advertisement it is mentioned that the selection shall be district-wise,
Yes.
so if the candidates are to apply against a particular district, or then probably the judgment may be correct that because he had applied against that district, so his merit is to be considered against that district only. No, here is a combined competitive examination. A total merit list is to be prepared.
I'm grateful.
And thereafter, based on preferences,
I'm grateful.
They are to be allotted districts. This is your submission.
And to add one more line, my lords, when he applied also, he gave a preference of 30 districts. Because he was also conscious that if I don't fit in one, I'll fit in one of the 30. But he would fill in one of the 30 if he qualifies in the test. If he is not there, if he is not there in the computer-based test list at all, then can he be considered for any district? That's the point.
No, every candidate who applied,
yes,
was entitled to be considered for all districts against which he had given preferences. First, second, third, or fourth.
Correct.
This is your...
provided he qualifies.
Yes, provided he qualifies,
yes.
He has to be considered for all the districts for which he had given preference. Annexure 8.
978 repetition.
I got the copies. Can I pass on?
Repetition we have.
Yes. The annexures they have not given. It is with the annexures. If my lord want, I
annexure.
The repetition I have.
You can see this one.
This is the repetition I have got. Copy for my.
This is the document my learned Advocate General cites.
This is part of writ appeal.
Yes, in the part of the writ petition, out of which this appeal arises. And kindly see page 40. This is annexure 3 series to the writ petition.
Yes.
Your Lordship is similar. This is the candidate about whom we are discussing, Chintamani Bhuiyan. Your Lordship may see application number. On the right side is Chintamani Bhuiyan. My Lordship's have it, perhaps. Now let us see what he does. Father's name is so and so, mother's name is so and so. City preferences, Bhubaneswar, where he will give his exams. Bhubaneswar, Cuttack, Jagatsinghpur, Nayagarh. Kindly turn over the page. District preferences for joining. My Lordship's have it, perhaps. So therefore, it is not his case that I only applied for one district.
Nabarangpur, yes, given first preference.
I am grateful because he was aware that based on the CBT test, if he qualifies, he has to not give only one. He has to give several. And he gave all 30. So my submission to your Lordship is this. He has to first get into the CBT test qualification. After he is shortlisted, his district will be organized depending on his preferences. That's all. Now, my lord, I will show your Lordships a few judgments and I'm done. Can't do it. I'm sorry. Filling up of medical posts. And this is 1968 2 SCR 786. This is a Constitutional Bench judgment. Williams. So here, at page 2 of the judgment, your Lordship will have paragraph 2. Rule 8, which is another rule under challenge, provides that the seats reserved in the general pool and seats reserved for the socially and educationally backward classes will be allocated among the various districts on the basis of ratio of population of each district to the population of the state. My Lordships have it based on districts. Now, my Lords, may kindly turn to paragraph 9, which is at page 5, because they are dealing with the validity of this rule. Paragraph 9, my lord. At page 5, my lord, sir, para 9.
Yes.
The next attack is on Rule 8, which provides for a district-wise distribution of seats according to the population of the district. This is attacked first on the ground that it violates Article 51. My lord, I will not read this because they have not agreed with this attack. If my lords kindly turn over the page, my lords, they say 15 is not violated. Let me straight away go to para 10. My lords, sir, para 10, my lord. In the alternative, it is urged that district-wise distribution violates Article 14 of the Constitution because it denies equality before the law or equal protection of the laws, in as much as such allocation of seats may result in candidates of inferior caliber being selected in one district, while the candidates of superior caliber cannot be selected in another district. Exactly what your lordships are seeing in this case. Somebody with a higher mark is going out and somebody with a lower mark is getting in. Let me read further.
No, this can happen.
Yes, sir.
This can happen if you have one combined selection.
For one district.
No, for all the districts.
Correct.
You have combined selection.
Yes, sir.
But in the advertisement,
Yes,
you
sir.
point out
Yes, sir.
that you can apply against this district.
Correct.
One can apply against this district. Then the selection process for that district is confined to one selection process.
Correct.
Though your selection process
Correct.
is combined.
Correct.
So this can happen.
Yes, sir. Let me read further.
Yes.
Principle 1 is so and so. It has not been denied on behalf of the state that such a thing cannot happen, though there are no statistics available in this behalf because the mark sheets were all destroyed after the interviews. Para 11. The question whether district-wise allocation is violative of Article 14 will depend on what is the object to be achieved in the matter of admission to medical colleges. Here your lordship will read it, my lord, for selecting teachers to teach. The object of selection can only be to secure the best possible material for admissions to college, subject to the provision for socially and educationally backward classes. So this is the rider. Further, whether selection is from the social and educational backward classes or from the general pool, the object of selection must be to secure the best possible talent from the two sources. If that is the object, it must necessarily follow that the object would be defeated if seats are allocated by districts allocated district by district. It cannot be and has not been denied that the object of the selection is to secure the best possible talent from the two sources so that the country may have the best possible doctors. If that is the object, the argument on behalf of the petitioner appellant that it is the object cannot possibly be served by allocation district-wise. It is true that Article 14 does not forbid classification, but classification has to be justified on the basis of the nexus between the classification and the object to be achieved, even assuming the territorial classification may be a reasonable classification. The fact, however, that the classification itself is reasonable is not enough to support it unless there is a nexus between the classification and the object to be achieved. Therefore, as the object to be achieved in a case of the kind with which we are concerned is to get the best talent for admission to professional colleges, the allocation of seats district-wise has no reasonable relation with the object to be achieved. If anything, such result will result in many cases in the object being destroyed, and if that is so, the classification, even if reasonable, would result in discrimination in as much as better qualified candidates from one district may be rejected, while less qualified candidates from other district may be admitted from their own two sources, from either of the two sources. So they have gone really one step forward, Willards, to say that such a rule also will be frowned upon. Kindly turn over the page, Willards.
Yes.
Lord, you may see, Millard, there is one line which starts after 7-8 lines. We are also satisfied. and there is no nexus between the territorial distribution and the object to be achieved, namely admission of the best talent from the two sources already indicated. We are therefore of the opinion that allocation of seats on the district-wise basis is violative of Article 14. We may add that we do not mean to say that territorial classification is always bad under all circumstances. But there is no doubt that district-wise classification, which is being justified on territorial basis, in these cases is violative of Article 14, for no justification worth the name in support of the classification has been made out. We therefore hold Rule 8 providing district-wise allocation is bad as it violates 14 and therefore we struck it. So they said that rule said district-wise. They said, look, you are looking for the best talent. So you can't say that district-wise or territorial-wise.
No, but this was whether on the basis of residence of a particular candidate.
Correct.
Here,
Yes.
A resident of Khurda,
Yes, my lord.
could
Could
give
apply anywhere. Correct.
First preference
Yes.
for, say, Malkangiri.
Correct. But what they say is that when you are selecting an MBBS student, select the best talent. Don't restrict it to any district. Here I am saying that if I am selecting a teacher, the students of Malkangiri, Bolangir or Khurda, any matter, any district, they should have the facility of getting taught by the best. That is why you had a CBT exam, otherwise there was no reason. Remember, this is one. Kindly see one more judgment. Now this is Radheshyam Singh, where a zonal consideration was being considered. People were applied, so they said, okay, for A zone, these candidates. Kindly see para 2 minutes. May Lordship may kindly see para 3 at page 62. This is my Lord, sir, para 3.
Yes.
According to this said advertisement, recruitments were to be made zone-wise on the basis of a separate merit list drawn from each zone in respect of the candidates who appeared at the centers within the same zone. The relevant portion of the said advertisement, which relates to zone-wise process of selection of candidates for the said post, as stated in para 16 of the advertisement, for ready reference is reproduced. Your Lordship may skip all that minutes and kindly come to paragraph 7. This is just above placetum H.
Yes.
The question therefore arises for consideration is whether such a selection based on zonal basis would be permissible or would it violate the constitutional guarantee enshrined under 14 and 16 of the Constitution of India? This is the question, my lord, the Honorable Supreme Court poses for itself. Now, paragraph 8. It is needless to emphasize that the purpose and object behind holding a recruitment examination is to select suitable and best candidates out of the lot, and such an object can only be achieved by making a common select list of successful candidates belonging to all zones. On the other hand, if zone-wise selection is made, then various candidates who appeared in some of the zones and secured more marks than those who secured from other zones would be deprived of their selection, resulting into great injustice and consequent discrimination. Thus, there can be said to exist no nexus between the aforesaid process of zone-wise selection and the object to be achieved, that is selection of the best candidates. That being so, the process of selection envisaged in para 16 of the advertisement in question and reproduced in the earlier part of the judgment would lead to discriminatory results, because adopting this said process, zone-wise selection would result in devaluation of merit at the selection examination by selecting a candidate having lesser marks over the meritorious candidate who has secured more marks, and consequently the rule of equal chance for equal marks would be violated. Such a process would only be against the principles enunciated in Article 14 and 16 of the Constitution, but it also result in heartburning and frustration amongst the young men of the country. The rule of equal opportunity, Lordships have read it, and then I need not trouble your Lordship. But one more judgment, and I'm done. This is 2021 4 SCC 542. This is 2021 Volume 4 SCC 542. Yes. This is Saurav Yadav and others versus State of Uttar Pradesh. And if my lords are kindly pleased, this is Justice Bhatt's concurring judgment. And it is at yes, paragraph 38 and 39. The second view is thus neither based on the authoritative pronouncement of this court, nor does it lead to a situation where merit is given precedence. Subject to any permissible reservation, either social, vertical, special, opportunities to public employment and selection of candidates must purely be based on merit. Any selection which results in candidates getting selected against open general category with less merit than the other available candidates will certainly be opposed to the principle of equality. There can be special dispensations when it comes to candidates being considered against seats or quota meant for reserved categories, and in the theory, if it is possible that more meritorious candidates coming from open general category may not be selected. But the converse can never be true and will be opposed to the very basic principles which have all the while been accepted by this court. Any view or process of interpretation which will lead to incongruity, as highlighted earlier, must be rejected. The second view thus, para 39, the second view thus will not only lead to irrational results, where more meritorious candidates may possibly get sidelined, as indicated above, but will of necessity result in acceptance of a postulate of open/general candidates or reserve candidates other than those coming within the vertical. So I am relying on the first line, and that's it, perhaps. I'm grateful to your Lordships. Please.
Lordships, I guess we've been greatly benefited with the Honorable AG's argument. Not much to add except this that which in fact fell from your Lordship's mouth also, is that this was never meant to be actually a district-wise or a residence-based recruitment.
See, there could have been two results. One, purely based on the merit. Only based on the merit for the entire state, based on preference also, and then that one merit list would have been bifurcated, divided, again based on preference. So there would be no difference between the first merit list, the candidates in the first merit list, and those selected, those divided, bifurcated from them based on preference district-wise. Am I clear? So only a separate merit list, like it's a kind of allocation to districts. So one from one combined merit list, you are allocating, the state is allocating different districts.
Yes, and I think one thing which I wanted to bring to your Lordship's notice is this, that each one of them was actually allowed to participate for each and every post, irrespective where it is placed. That's very important. All that it probably the state did, instead of state preferring, you are allocated this or that, allowed that you make your preference or your first or second preference wherever you want to be placed according to the marks that you secure. So state never wanted to do away with the merit issue. So that's very important, because when it happens, if it was completely district based, then in fact they would have also asked for a residence certificate or something. That was not at all the case here. So
no, residence was never the criteria.
Never the criteria.
Reference had some criteria. And
according to your preference, you do get allocated. That's all. But this preference was never meant to absolutely not allow people who are higher up in the merit to go away. Because as I last time also submitted, the extreme of that argument would be that only because I preferred, I'll get a seat even if I secure 0. But that's possibly not. And I think that would be a very compromising situation vis-a-vis the state, and state would vis-a-vis the districts, which state would never want to do. Especially want to maintain a particular standard of education throughout the state. That's all would be to look at the entire thing from that perspective. That's all I would add. Otherwise, everything has been covered by a honorable.
May I be permitted to supplement Land Advocate General, sir? Sir, I only supplement by some 2-3 judgments. But one thing, as your lordships pointed out, so far the merit of the case is concerned, in fact, on 10/9/2023, which was placed by the Land Advocate General, the candidates will be selected on the basis of the marks secured on the CBT computer-based test examination. This was circulated about the candidate, and candidates were aware before the process of selection was started, before the CBT exam.
There is another aspect.
Sir.
The notice, the advertisement was not contrary to any provision under the resolution.
Under reservation.
Under resolution.
Oh yeah,
resolution. So that the process which was adopted was not in conflict with any provision under the resolution 8.2, 8.3.
Right. So therefore, 8.2 read with this notice dated 10/9/2023 makes it very clear. The candidates will be selected on the basis of the marks secured in the CBT computer-based test exams. That's all. And you also already read 8.2 and 8.3. What comes to my mind?
And the district-wise posts were not advertised.
No, sir. According to my submission, 8.2 is the preparation of the merit list through the computer-based test, and the allocation is 8.3, if I have correctly understood. And what comes to our mind, that here is a question of merit and the preference of the district. This comes two things. I have got two judgments. Here is a case. AI 2006 Supreme Court. I don't want to again further add something which Land Advocate General already clarified to your lordships, and they have given also illustrations. And this judgment, if your lordships will come to where the merit and the preference is there, what will be which will be preferred? Let's say look to paragraph 4. Paragraph 4. To appreciate the real controversy in perspective, it is necessary to notice the requisite qualification mentioned in the advertisement as per the requirement of Rule 8 of Uttar Pradesh Homeopathic Medical Service Rule 1990. These are the academic qualification, the entry of the recognized degree in homeopathic, that is the minimum qualification. But you also see the bottom. It will be noticed from the above quoted rules that in addition to the requisite qualification, a proviso has been added, inverted comma, preference will be given to the degree holders. The real controversy starts from the proviso that preference will be given to degree holders. Then also straight we come to the last but one page, the judgment in 2003 BB Commission versus YBBR Srinivasan that has been quoted. Let me read that quotation, then I'll take also to paragraph 12. The word preference.
Which paragraph?
That is paragraph 11. Just above paragraph 12.
Yeah.
The quotation. The word preference, in our view, is capable of different sets of meaning, taking color from the context, purpose, and objects of use on the scheme of things envisaged. Hence, it is to be construed not in isolation or detached manner, ascribing a meaning of universal import for all contingencies capable of an invariable application. The procedure for selection in case involves a qualifying test, a written examination, an oral test or interview, and the final list of selection has to be made on the basis of the mark obtained in them. The suitability and all around merit, it has to be adjudged in that manner only. That justification could be there for overriding all this merely because a particular candidate is in possession of an additional qualification on the basis of which a preference has also been emphasized. The rule do not provide for separate classification of those candidates or apply different norms of selection for them. The preference, inverted comma, envisaged in the rule, in our view, under the scheme of things and contextually, also cannot mean an absolute en bloc preference akin to reservation or separate and distinct method of selection for them alone. A mere rule of preference meant to give weightage to the additional qualification cannot be enforced as a rule of reservation or rule of complete precedence. Such a construction would not only undermine the scheme of selection envisaged through the Public Service Commission on the basis of merit performance, but also would work great hardship and injustice to those who possess and the required minimum educational qualification with which they are entitled to compete with those possessing additional qualification too and demonstrate their superiority merit-wise and their suitability for the post. It is not to be viewed as a preferential right conferred even for taking up their claims for consideration. On the other hand, the preference envisaged has to be given only when the claim of all the candidates who are eligible are taken for consideration and when any one or more of them are found equally positioned by using an additional qualification is a titling factor in their favor vis-a-vis other in the matter of actual selection. Then paragraph 12. In the instant case, the requisite academic qualification for the post of homeopathic as prescribed in the advertisement was recognized a degree in homeopathy or a recognized diploma in homeopathy. A proviso has been added that the preference will be given to the degree holders. This would mean that a recognized diploma in homeopathic prescribed in the advertisement is also a required minimum educational qualification with which they are entitled to compete with those candidates possessing the degree. The word preference would mean that when the claims of all candidates who are eligible and who possess the requisite educational qualification prescribed in the admission are taken for consideration, and when one or more of them are found equally positioned, only the additional qualification may be taken as a titling factor in favor of the candidate vis-a-vis others in a merit list prepared by the Commission. But preference does not mean en bloc preference irrespective of inter-se merit and suitability. This is one. Another.
So there is difference between the preference which has been dealt with in this judgment and the preference in the present selection process.
Yes.
There the preference, the selection body gives.
Right.
The state gives. State gives that preference. Here, the preference is to be given by the candidate.
Yes.
For the purpose of allotment of a district.
Allotment
This
of
is
a
the
district.
difference between. But yes, the law, the crux remains that merit has to be given.
Merit has to be given. That is what my entire.
But the preference in this and preference.
Is absolutely correct. Absolutely correct. There the state has done it or the employer has done it. Here the candidate themselves have done it.
Have to prefer. They have 10 choices.
Yes, sir.
Which will you prefer?
Right, sir. Right. So now the question is, sir, the merit. Merit cannot be sacrificed. And I don't know, possibly it is for the state. So far 8-2 is concerned, they have prepared a list. So far as these 4 candidates who have approached this Honorable Court, whether their names at all found place in that merit list that was just prepared in terms of Rule 8-2, I don't think. And even if their names found place, even if their name must be below that list. So they cannot be compared to a person. But I just give an example. Suppose the district Khordha, there are only 10 posts and 30 candidates are giving their preference to Khordha district. But it is the employer's duty, the state duty to give those candidates according to that preference. They will give the other candidates who cannot be accommodated as per their merit to other district. So therefore, under no circumstances merit can be sacrificed.
There can be another example.
Sure.
I don't know this thing in demography and the economic conditions. But suppose Kalahandi,
Yes, sir.
Look, for Kalahandi, the first preference is made by, say, 20 candidates only out of 1 lakh. So,
Right.
can it be a situation that those 10 candidates will have to be selected for Kalahandi, whatever their performance is?
Absolutely, absolutely right. Your answer is correct. Correct. That is the position. Cannot. So therefore, the has to be the merit list cannot be ignored. So far as the post judgment is concerned, what they have prepared, I found these 4 candidates, even including the petition number 1, the private opposition party, they have secured the marks much below the marks secured in the last candidate in any other districts. So the category 2. So for the Malkana, in that case, if the Honorable Single Judge judgment is accepted, that means a candidate who has secured 146 has to be selected, and a candidate who has secured 176 has to be ignored. That means in between 2, the merit has to be sacrificed. That is what another judgment I'm just giving. I close my argument. This is also at paragraph 14. Let us now examine the question of college-wide institutional preference, para 14. From the point of view of Article 14 of the Constitution, by the impugned rule, a classification.
You are reading which paragraph?
Para 14. Para 14. 1-4.
Yes. Please.
Let us now MBBS degree from the other colleges. In order that a classification is a permissible one within the meaning of Article 14 of the Constitution, 2 tests have to be satisfied. Namely, 1, that there is an intelligible differential which distinguishes persons grouped together from those who are left out of the group. 2, that there is a rational nexus to the object sought to be achieved by the impugned rule. The object sought to be achieved by the impugned rule is obviously to prefer merit for the postgraduate course and to exclude less meritorious candidate. Then you also kindly come to paragraph 15, middle portion. Paragraph 15, middle portion. Thus, although you also from paragraph 15, 1, 2, 3, 4, about 8 lines from the top. Thus, although Dr. Anjali Swansu and Dr. Sumit Swansu secured more marks than the student admitted in the postgraduate course in Swansu in said GS Medical College, except the said Dr. Ganapati Sawan, they refused admission in view of the college-wide institutional preference. Similarly, in respect of other discipline, many meritorious students could not get admission even though they secured higher marks than those admitted in the postgraduate degree course by virtue of the impugned rules. Thus, there is a patent discrimination in as much as the students obtaining lesser marks have been preferred to those obtaining higher marks. There is no intelligible differential for the classification by way of college-wise institutional preference as provided by the impugned rule, distinguishing the preferred candidates in respect of each college from those excluded from such classification. By such classification of college-wise institutional preference, merit has been sacrificed. Far less it has been preferred. When the university is in the same for all these colleges, the syllabus, the standard of examination of a skip over, last line. In such circumstances, college-wide institutional preference cannot be supported, and it has already been noticed that this court has not approved of such preference at all. These are so far the merit is concerned. Well, I have already argued before the Law and Advocate General has argued. Well, so far as the impletion of party is concerned, I have already argued. One judgment I will show you answers. Even the Honorable Supreme Court has gone to an extent that if a person is a necessary party but has not been implemented as a party, then that judgment is ab initio void. That is null and void. That is a judgment, Kulwant Singh's case, which has been referred to by a division bench of Permanent Justice Sharangian. That judgment I'm not giving, but the Supreme Court judgment I'm giving at paragraph 39 and 40. Copy. Yes. Court in ordinary civil appeal. In a civil appeal, yes. Civil appeal.
It's not a judgment. Order in SLP, that is referred to.
Judgment.
No, this judgment, if you also will look to, just I'm showing it, para 39. Para 39. If you also will look to that para 39.
Yes.
But you also note that L. Chandra Kumar case has been referred to.
Yes.
First, we look at the facts of non-impletion, which was been highlighted by Mr. Gupta. The said submission has two limbs. First, the mere awareness of the pendency of litigation, because it is mentioned subject to the discharge of the original application, does not make the order binding upon him. And the second, by the time the judgment was pronounced, all the respondents were sent for lower courts and promoted, and therefore they are clearly identified as ultimately affected parties. Hence were necessary parties for the purpose of adjudication of the lease. Para 40. At this stage, we shall notice certain authorities which have been commended to us for adjudicating the effect of non-impletion of party. In Khetrabasi Vishwas case, let's just skip over that case of Odisha. You also skip over to next page.
Yes.
Next page. The appellates who had come to this court were not parties to the writ petition. The High Court, while preparing its own list, did not think it fit to issue notices to other candidates like the appellant before this court, who has suffered prejudice by the regions of the directions issued by the High Court. By dealing with the justifiability of the same, this court held that they were necessary parties. In that context, expressed thus quotation: the procedural law as well as the substantive law both mandates that in the absence of a necessary party, the order passed is a nullity and does not have a binding effect. The other judgment I have already given. I did not take your worship for much time. I'll only give a memo of citation and I'll give to your worship. That's my.
Yes.
The small petition progress also discuss
Since Learned Advocate General and all other senior advocates, they have placed their submission. I'll not take much time of my lord's lord. Limit it to only 2-3 points.
So we'll come back within 2 minutes.
Right. But yes,
Local why?
the reason being from the charts demonstrated by the Learned Advocate General. Either way, if it's a district-wise selection of
The question of locals can be referred to at the time of presenting the application.
correct, my lord.
So at the time of presenting the application, they had the locals because they were questioning the process of selection,
They were
the result.
regent, not the process. Process they had a locus.
No, process, no, they had challenged the result.
Right.
The result in which their names did not figure. All right, they questioned the result in which their names did not figure in respect of a selection process in which they had participated.
Correct, my lord.
Locus, you may say that after whatever the
result has come out.
done, the merit
Now,
list, and then the
You did not have
district
any
is
more
also-
cause of action. You did not have any more cause of action because your name doesn't figure in the merit list either way, either district-wise or state-wise. Keeping those charts in view, those demonstrating.
Locus, you may say that in view of these two
Demonstration.
demonstrations,
Correct.
they do not have any
So
case.
grateful.
So there was no
So great.
no reason for
Approaching them
interference.
before the High Court.
No, approaching they had,
Correct.
but there was no requirement of interference.
Right. my lord.
So
Ajal.
if that you may say.
That's right.
Locals,
Page 34.
yes.
Book is that. Para 34. Para 34. Para 34, my lord, that's exactly on the same line. Para 20. The Lordship may kindly see para 20 first. In Bar Council of Maharashtra, so a bench of 7 learned judges of this court considered the question whether Bar Council of a state was a person aggrieved to maintain an appeal, so and so, so and so. The meaning of the word a person aggrieved may vary according to the context of the statute. One of the meanings is that a person will be held to be aggrieved by a decision if that decision is materially adverse to him. Normally, one is required to establish that one has been denied or deprived of something to which
one is legally entitled to in order to make a person aggrieved. Again, a person is aggrieved if a legal burden is imposed on him. Meaning of the word a person aggrieved is sometimes given a restricted meaning in certain statutes, which provides remedies for protection of private legal rights. The restricted meaning requires denial or deprivation of legal rights. A more liberal approach is required in the background of statutes which do not deal with property rights, so and so on, morality. The role of the Bar Council of Advocates Act is comparable to the role of guardian in professional ethics. Word person aggrieved, section 37-38 of the Act are of wide import and should not be subjected to restricted interpretation, possession of denial of a legal right or burden financial interest, etc. Now your lordship may see para 34. Para 34. This court has laid down in a number of decisions that in order to have the locus standi to invoke the extraordinary jurisdiction under Article 226, an applicant should ordinarily be one who has a personal or individual right in the subject matter of the application. Though in the case of some of the writs like habeas corpus or quo warranto, this rule is relaxed or modified. In other words, as a general rule, infringement of some legal right or prejudice to some legal interest inhering in the petitioner is necessary to give him a locus in the matter. So and so, the judgments made.
Yes.
But I stop it on the question of locus here, Milord. Now, your lordship may say with regard to non-implementation of party, my learned senior Mr. Rautra has placed judgments. But I have only a supplementary judgment to that effect. 2020, volume 2 SEC, page 173. Para 72 straightway.
2020 volume.
2020, 2 SEC, page 173. Para 72. I've given a copy for my lord's convenience.
Yes.
Para 72. When the selection of successful candidates is challenged,
Yes.
when the selection of successful candidates is challenged, depending upon the facts and circumstances of the case,
Which paragraph?
Para 72, Lord, I'm so sorry. Para 72.
Yes. Yes.
When the selection of successful candidates is challenged, depending upon the facts and circumstances of the case, the successful candidates ought to be put on notice about filing of the writ petition by impleading them by issuance of notice in accordance with law by Pune versus State of UP. In the present case, we are not inclined. The Honorable Supreme Court was not inclined to accept that because they were put to notice. The successful candidates are put to notice. That is why the Honorable Supreme Court has said, but has laid down the law, well-established position that they are bound to be implemented as parties and put to notice.
Yes.
Here in this case, not a single successful candidate was implemented as a party, nor they were put in notice. And coupled with the other judgment, a decision rendered without implementing a necessary party, a person as a party is void ab initio and not binding on them. Now, my Lord, my third contention before my Lord should be, your Lordship would see page 99 of my brief, my Lord. Lord, which correctly fell from my Lord's mouth. Kindly see, my Lord, that whether this is selection is state-wise or district-wise. It is one thing to say that selection is state-wise or district-wise and allocation of vacancy to the districts for the purpose of appointment from the common list. Am I clear, ma'am? Now, if your Lordship sees at the cost of repetition, page 99 of my brief may vary in the other brief, my Lord. Just one line I'll paste. The candidates, Lord,
Which appeal?
Lord, this is writ appeal 740 of 2024. How would you call judgment answer?
740.
Right, Lord. My writ appeal is 740 of 2024.
Yes.
Page 99.
Annexure.
Lord, annexure, this is Lord, annexure 2 of the writ petition, Lord, before the Honorable Singh Judge. Running page 99. That is the advertisement.
Yes.
Lord, that is the advertisement forming basis of all these people to apply and get their selection, man. Lordship sees in the second paragraph from the bottom, the candidates will be selected.
Yes.
The candidates will be selected on the basis of marks secured on CBT computer-based test examination.
Yes.
The syllabus of CBT examination is available in OSEPA website. The date, time, examination, CBT is not very relevant. So what the advertisement itself said, that the candidates will be selected based on CBT examination. Advertisement do not say there will be district-wise selection. Never says that. Next, my lord, to avoid that confusion, whether the district-wise selection or district-wise vacancy. Kindly see the next page, my lord. Kindly turn to the next page, page 100. I'll demonstrate it from this document, my lord. This is a part of the document filed by the petitioner himself.
Yes.
Lordship will see the district-wise vacancies are indicated here over this page. So obviously, the authority never meant that there will be a district-wise selection, but allocation district-wise will be there.
Yes.
Now, Lord, coming to the next point, Lord, anticipating that they may try to put forth a case that district-wise selection will have a preference over merit. That they may say, referring to a particular clause in the advertisement, in the resolution, they may say that. Kindly turn to that page, my lord. That is clause that very 8.3, page 92 of my brief, man. Page 92, clause 8.3. But at best, they may raise this issue before your lordship, saying that the district-wise list will have a preference over merit. A sentence is there. That is towards last of this page 93. Let me place it. Clause 8.3. District-wise and category-wise draft merit list will be published. That's what it will. I'm so sorry.
Yes.
District-wise and category-wise draft merit list will be published. This is post 8.2, post computer-based test. District-wise and category-wise draft merit list will be published in OSEPA website. Draft merit list will be prepared, taking into consideration all district preference submitted by individual candidates in order of preference, followed by merit rank, that is for a particular district. After exhausting all candidates having first preference, subsequent preferences will be considered. In case of a tie, this is relevant. I am trying to emphasize this. In case of a tie, that is, when two or more candidates obtain equal score, inter-se merit of such candidates shall be decided in the order as mentioned below. Roman 1, 2, you also may skip over. Last sentence. For a particular post in a category within district, district preference will be preferred over merit. Let there be no confusion on this, that this is a clause to meet the contingency of a tie inside the district, not affecting the state-wise merit list based on CBT test. Am I clear, my lord?
Yes.
This particular sentence is intended to meet a contingency which arises on account of a tie among the candidates inside the district,
Yes.
not affecting the merit list in the CBT test. Now, my lord, I'll cite one judgment. Merit cannot be sacrificed. Lot many judgments have been placed, my lord. One judgment only on that line. 2013, volume 14, SCC, page 623, para 14 and 15.
2013.
2013, volume 14, SCC, page 623, para 14 and 15. My lords may straightway come to para 15. Another witty reason.
Para?
Para 15.
Yes.
Another witty reason given by the High Court in the instant case while approving the aforesaid action of CCI is that the intention of CCI was to get more meritorious candidates. there was no change of norm or procedure, and no mandate was fixed that a candidate should secure minimum marks in the interview. In order to have meritorious persons for those posts, fixation of minimum 65% of marks for selecting a person from OBC category, minimum 70% mark for general category was legitimate, giving a demarcating choice to the employer. In the words of the High Court, in the case at hand, as we perceive, the intention of the Commission was to get more meritorious candidates. There has been no change of norms or procedure. No mandate was fixed that a candidate should secure minimum marks in the interview. Obtaining 65% marks was thought as a guideline for selecting the candidates from the OBC category. The objective is to have the best hands in the field of law. According to us, fixation of such marks is legitimate and gives demarcating choice to the employer. It has to be borne in mind that the requirement of a job in the competition commission demands a well-structured selection process. Such a selection would advance in the cause of efficiency. Thus, scrutinized who do not perceive any error in the fixation of marks at 65% by the Commission, which has been uniformly applied. The said action of the Commission cannot be treated as illegal, irrational, or illegal.
Yes.
But that's all, I'm deeply grateful.
Yes. You have a very difficult task for the reason that you have been under attack by the Land Advocate General and senior advocates and certain observations also from the court.
But end of the day, my lords are there too.
Yes.
My lord, to start with, I am holding the brief of London Advocate General, WA.
No, you are not holding his brief.
No, because I am to refer it from that brief. That is, because we can't make, because there are different data fields.
712. But 712 of 2020.
Right. Lord, here is the case with regard to recruitment of junior teachers. Their name is now schematic. There is a history of appointment of staffs in primary school, upper primary schools. What they have done initially, that was in the Shiksha Sahayak. Initially, what they have done, very fast, there was direct recruitment as a teacher. Thereafter, my lord, they have changed it. They have recruited Shiksha Sahayaks on a fixed tenure basis, and on completion of certain years of service, they are regularized as regular primary school teachers. Now, for the first time, they have introduced, after the Shiksha Sahayak, now this time, they have stated, no, we will introduce the junior teacher. Now they are saying schematic. Under the statute also, because this appointees ultimately merges with their service condition will be guarded under the Odisha Elementary Cadre Rule 1997 as it has been amended. So there is a connotation of junior teacher. Entry level, it is junior teacher. That is now, it will be level 5, 5A, 5B, 4, 3, 2, like this. That is there. With this background, we have to start. So now these junior teachers are appointed, or the Shiksha Sahayak, or the regular teacher, all are to be appointed in the primary schools. Primary and upper primary school, therefore there are two categories of posts. Their entry into the service is in a district cadre post. That I mean to say. Whatever name they enter into service, finally they fall into a cadre, which is a district cadre post. District essentially means revenue district. We have 30 districts in the state. So accordingly, this is a district cadre post. That is why all the selection made in that. Previously, before I am coming to this particular case, in the Shiksha Sahayak, identical problem arise.
No, but is that required? Let us confine to this problem.
Yes, sir. Because that is the next, because there is a order of this honorable court in the previous cases, identical issue. Identical matter. That was the issue. I quoted in the writ petition also. That is why I want to read that order first. Because that is history. When the Shiksha Sahayaks were entered into services, into the district cadre post. A identical problem was also there, and it has been answered by this honorable court, by the honorable single judge, which has not been challenged and it has been acted on. So may I take my lord to that part of the court? Page 101. That is part of my writ petition. I have quoted my lord's order there.
You want us to see the writ petition?
Yes, this is part of the writ petition. It is in running phase 101, man. That is WPC, that is quoted, man. 3319 of 19.
But they're not there.
Yes, my lord, it is page 101, man. In the writ appeal 712.
In the appeal, it is there.
Yes, yes, that is quoted in the writ petition. I am referring to the writ petition. Running phase 101. My lord.
Yes, sir.
Para 12 of that.
12, that is 14.
Yes.
Mine. I'm just
WPC 3319 of 2018.
3319 of 2018. Order dated 28 to 19. Heard Mr. SB General and Counsel for the petitioner, Mr. B. MPHIL and Standing Counsel.
Running page 101.
Yes. Yes.
Bye. Shall I read one? 100. Shall I read?
Yes.
Well, 102. The petitioners have filed this application seeking for a direction to the opposite parties to prepare the merit list of the post of Shiksha Sahayak as per the merit issue and issue order of appointment accordingly. Mr. SB General and Counsel for the petitioners brought to the notice of the court a resolution passed by the government in Annexure 1 and submits that as per clause 4.3, selection shall be made on the merit, that is, on the basis of percentage of mark. He further referred to clause 5, that is, mode of application, and clause 5.7 reads as follows. This is 5.7. District-wise, post-wise, and category-wise 100% merit list as per vacancies will be prepared by OPEPA through NIC as per district preferences submitted by the candidates and merit of the candidates. The draft will be prepared taking into consideration of all district preferences submitted by the candidates in order of preference, followed by merit, that is, after exhausting all candidates with first preferred district. Second and third and subsequent preferences will be considered. For a particular case post in a category within district preference will be preferred over merit. In course of hearing, a query was made by the court with regard to the selection to be done in respect of Shiksha Sahayak as a state cadre post or WPC number 3319 of 2008 district cadre post. Mr. SB General and Counsel for the petitioner has very fairly states that Shiksha Sahayak is a district cadre post. In that view of the matter, this court is of the view that if the Shiksha Sahayak is a district cadre post, merit list is to be prepared on district wise. Even a candidate secure higher percentage of mark in postal district, he may not be given an appointment in district cadre, but a candidate who secured less percentage mark in a district cadre, he may be selected. Therefore, this court doesn't find any illegality or irregularity in the selection held by the opposite party. Accordingly, the petition is disposed of with the liberty so and so. Now, at this juncture, my lord, I will take my lord to the government resolution. Test 72. Annexed to test 72. This was in respect of Shiksha Sahayak. Now we are in this particular selection for junior teacher schematic.
Yes.
Test 72. First paragraph. This is the subject is guideline for engagement of junior teacher schematic. This is the guideline prepared by the state for selection. Now we are para 3. In para 3, madam. In pursuant to section 23 of the SAD Act, National Council of Teacher Education NCT.
Oh, sorry.
Again?
You are referring to
72, my lord. This resolution.
72.
Annex 2.
Paragraph 3, yes.
In pursuance to 23, section 23 of the SAD Act, National Council of Teacher Education NCTE, being the academic authority, has laid down the minimum qualification for a person to be eligible for appointment as a teacher in class 1 to 8 by notification published in Gazette number 215 dated 25/8/2010, keeping in the view the provisions of the Act and the rules and the guideline issued by the National Council of Teacher Education. Government have issued the resolution bearing number so and so in supersession of the department resolution so and so. Let us skip over. Dated so and so, prescribing the guideline for engagement of Shiksha Sahayak, subsequently designated a junior teacher schematic. Now it is an access to the other case I have reported. As prescribed in the Odisha Elementary Education Method of Recruitment and Condition of Service Teacher and Officers Amendment Rule 2014, element teachers are appointed in the state through absorption of junior teachers after 3 years of continuous and satisfactory service, considering through a committee at the district level. A junior teacher schematic become eligible to be a junior teacher after 3 years of continuous and satisfactory service. Their 6 years of service, engagement, as mentioned above, will be co-terminus with that of Samagara Shiksha scheme till their absorption in the regular elementary cadre. NCT have been revised minimum qualification for prescribing this level. We let us give our next panel. Now the government have been pleased to supersede the previous resolutions and have decided to conduct the recruitment for engagement of junior teacher schematic through an online computer-based test as per the detail given below. 1. That all the function of elementary education will be transferred in phases to Jilla Parishad and other Panchayat Raj institutions. That the engagement of all junior teachers schematic will be made by the respective Jilla Parishad under the each category, that is class 1 to 5 and class 6 to 8, under the program of Samagra Shiksha SS for implementation of the SAD Act for elementary education. So this is for this district. My humble submission is this is for a district, and this is appointment ultimately comes to a district cadre post, and that is why the advertisement is. Now, my lord, the mode of application is para 4. Well, one thing I will say, para 3 of the advertisement, clause 3, clause Roman 3I. Intending candidate may visit OSEPA website for further information as mentioned below. A. District-wise number of vacancies and vacancy reserved for different social category, PWD candidate, ex-servicemen, sports personnel as OAVS and other prevailing act and rules. My lord have put me a question, put to them the question I was telling of my lord have kept me mouth. That my lord's question was in the course of hearing whether there was a post advertised for each district. Yes. At this juncture, I will continue further. They have stated district-wise number of vacancies, vacancy reserved for the post are advertised. In the advertisement, if my lord will see, because that is in my writ petition, I have given the vacancy position. It is page 30. They have not filed it. In the writ petition, if my lord will see, this is the vacancy position. At the writ petition, they have not.
We are giving you an example. Suppose constables are to be recruited in the state. Right. So it's I think district, the appointing authority is Superintendent of Police. So the vacancies would be district wise. The vacancies.
That is why I have read only 8.1 and I have kept it paragraph 3. My lord have put a question that there is a district.
District wise.
Question that there is a district wise advertised vacancies. Each district, how many posts are there, that is there. So the district wise. Now my lord straight will come to this paragraph 8, selection procedure, page 78. Page 78. Page 70 selection procedure has different phases. My response submission is this at the outset. What are the stages? After stage 1, stage 2, stage 3, like this, my lord, they are categorized. It is the government resolution. And the authorities have to act accordingly. So now, my lord, what is stage 1? Application intending candidates have applied for. Those are found eligible. A list is to be prepared. My lord, kindly say stage 1. What is 8.1? Public plus 78. My lord, I'm reading. Yes. 8.1. Publication of master list. After expiry of last date of submission of online application form, comma, list of candidates for each category with respect to their first preference district as submitted by them at the time of submission of application form will be published in OSEPA website, full stop. After these applications were submitted by different candidates, because there are two categories of posts are advertised, para 5. Category 1 is for class 1 to 5 and category 2 is for class 6 to 8. These are the two categories. One candidate also eligible for apply for both. So what the first stage says, after the applications are received, the OSEPA is to categorize the candidates on the basis of their first preference district. At that point of time, there is no examination, ma'am. This is the first stage. I'll be slow again. I'll repeat again. After expiry of the last date of submission of online application form, list of candidates for each category with respect of their first preference district as submitted by them at the first submission of application form will be published by the OSEPA in a website. A list of first preference candidate of each 30 district has to be published. And
You are reading which clause?
Clause 8.1, man. Yes, 78.
Read it again.
Mine.
78.
After publication of master list, man. That is called master list.
Yes.
After expiry of last date of submission of online application form, comma, list of candidates for each category with respect to their first preference district as submitted by them at the time of submission of application form will be published in OSEPA website. The next sentence says, information on subsequent preference district of each candidate will also be available in OSEPA website on search. That is on search. For the first, the thing is to be done by the authority. On receipt of the application form, they will segregate the first preference district of each candidate because there are 30 districts. Each candidate is bound to give 30 preferences, 1, 2 to 30. So suppose a candidate has given first is Nabarangpur, let us say. All the candidates from amongst all the candidates, whatever the application come, they will choose the first preference district so far Nabarangpur is concerned.
So therefore, we had given you this example,
Right.
that if there are 30 persons
Right.
who apply for, say, a district Kalahandi,
Right.
they give first preference.
Right.
There are 30 posts and only 30 give first preference.
Right.
Then those 30 are to be selected.
That is the scheme. Right?
That is
The next stage, my lord, we'll get our answer. My answer is definitely, my lord, because what is there in the mode of selection?
Yes.
I will say yes.
Yes.
That is that can be, my lord. Kindly see. So now, my lord, what happened at the first stage, before the examination was, I'm just repeating, my lord. I'm sorry. Before the examination, on receipt of the application.
Yes, we have understood your
Right,
submission.
obliged, much. So now the next stage is after segregation of first preference candidates. Now 8.2 online computer-based test. This is central test. An online computer-based test will be conducted by OSEPA, an authorized agency, as per the syllabus contained in the advertisement to be published before the recruitment. So there will be a central selection for all the candidates. Unlike OPSC, unlike PPSC, all the selection will be made in one place. So selection was made. So next, after the selection is over, first is the list, thereafter master list, thereafter the examination. The examination thereafter 8.3. Now our bone of contention is 8.3. District-wise and categorized draft merit list. Now I'll read it along with 8.1. 8.1 already there is a first preference district list with them. So now the examination is over. Now the marks are treated into the first preference marks. So now, my lord, what is the procedure? District-wise and categorized draft list, merit list, will be published in OSEPA website. Full stop. Draft merit list will be prepared. Now, probably this is the answer. Draft merit list will be prepared, taking into the consideration all district preference submitted by the individual candidate in order of preference, followed by merit rank. That is, for a particular district after exhausting all candidates having first preferences, subsequent preference will be considered in case of a tie. Now, my lord, we'll stop it here first, my lord. What does it say, my lord? As my understanding, subject to my lord's approval, the OSEPA website, after getting the marks, put it to the list prepared on master list order 8.1. Because after 8.1, my lord, now they have a list. Suppose currently 30%.
Yes, sir.
So marks will be fitted to them. And thereafter, there will be a descending order of mark. Because the person who has secured high mark will be number 1. So likewise, my lord, it will be descending. So accordingly, they have said preference will be followed with the merit. It doesn't say merit will follow with the preference. Had it been so, my lord, I have no case. So now you have the list, you have the marks, put into that in accordance to their marks and get the final list. Then what to do is, for a particular district, thereafter the first important, after exhausting all candidates having first preference, subsequent preference will be given. At the first instance, though I have applied for 30 districts, if all the candidates, as per the vacancy position in different 30 districts, are exhausted, then there is no question of second, third, or 30th preference. If 30% applied,
other district merit candidates cannot also
come to this matter.
travel into
Other districts. If they have opted for, if that is my lord fine, as per the scheme of Board of Selection, if I am directed to submit a preference and on my own volition I have preferred Cuttack, but I have secured good mark or bad mark, then Kalhandi. Even if less percentage mark, person secured less mark than me has been now observed in Kalhandi, I could not march into that place because I have not preferred it. That is the scheme. And it is none of the parties' case. Nobody is challenging this procedure. Nobody is questioning this. Neither now those are saying that we have secured very good marks. They are not questioning that. Had it been a case that yes, this rule 8.3 has been challenged, merit is to prefer over the preferences, the case, what is argued before minority is understood. But here is a case, the procedure is codified and it is done by the government. So now the state cannot come and say that no, it is wrong. A merit is to prefer over. So that is why, minority, it is said after adjusting. So now, first of all, this 8.3 has to prepare as per the list. And the tie and all these things, that is there. So if they are getting it list, at this juncture, minor, thereafter, 8.4. The next thing, after this adjustment all these things, after publication of the draft merit list, all candidates in the said list will be called for verification of original documents at their respective district headquarters. Necessarily means, pilot, again I will go to clause 8.1 and 8.3. The list is of the first preference, and now you will be called to your first preference district, and your records of certificates will be verified in that particular district. So therefore, a draft list as per the first preference district has to be published. But what they have done at this juncture, the verification of documents were fixed to 20th and 21st of December. At that juncture we came, because there was a draft list. What they have done, madam, that is a mistake. At this juncture, after 8.3 and 8.4, at that juncture we came. A draft list was published in Annexure 6 series in the writ petition. That is how they have done it, my lord. They have not given it. Again, it is in my writ petition, if my lord will see. As per the mark, the OSEPA has allotted the districts, not as per the preference. If my lord will see Annexure 6 for a moment, which is impugned before this, because what I have challenged in the writ petition. Kindly see, my lord, my prayer. Page 106. At this juncture, my lord, what was my prayer in the writ petition?
Yes.
My lord, page 104, sorry, my lord, page 104. My
On the writ petition.
Writ appeal, my lord.
Writ appeal.
Writ petition, my lord, it is writ page 14.
Huh?
If my lord holding my writ petition, page 14.
No. Come to
Writ appeal.
writ appeal.
My lord, 104. The prayer in the writ petition. My lord.
Yes.
My lord. Under the above circumstances, it is therefore humbly prayed that this honorable court be graciously pleased to pass the procedure adopted by the OP number 2 for selection of junior teacher schematic and also the draft result sheet under Annexure 6 series, and direct the opposite part number 2 proceed with the selection strictly in accordance with the government guideline in resolution dated 22/8/23 under Annexure 1 and to engage the petitioner in their preferred district with all consequences and financial benefit within a stipulated time, so and so, so and so, so and so. Because there was a wrong draft list, not adhering to either.
So you did not challenge the draft list.
Pardon, madam?
You did not challenge the draft list.
No, I have challenged, madam. Annexure 6 is
Not
the
in
draft
your
list.
prayer.
Prayer I have read now, madam.
Please to quash. No, you want quashing of the procedure.
No, draft select list. Shall I read once again, madam? Was the procedure adopted by the opinion number 3
And also the draft.
and also the draft list, Annexure 6.
Following.
So because our cause of action only came from looking into the draft list which are published. Instead of the first preference listed, what they have done, they have allotted. They have given a go by to that particular preference we have given, asked by them to give. They have preferred as per their mark or whatever the condition, I don't know. They have said, though I have preferred, suppose Navarampur, I have been directed to appear in Balangi or Palandi or some other district as per my mark. But that was not the purpose of this procedure or the advertising. If the procedure, my submission, my lord knows, because I should not dare to say, but that famous Nazir Ahmad case, my lord, if thing is to be done in a particular manner, it has to be done.
Mr. Counsel, the problem is,
Well, sorry, if I have committed wrong.
if we accept your submission
Well,
and read those provisions like you are suggesting, you may be correct also, then the process itself will have to be held to be ultra vires Article 14 and 16.
I don't know, but that my submission at this stage is nobody is questioning that.
Even if
yes, that is there, madam. That is there because now we are in a appeal against the order of the Honorable Single Judge. Before the Honorable Single Judge or any other writ petition, nobody was questioning the procedure adopted by this state.
even if no one questions,
My lord can have it. My lord, I am not questioning, but now I am in the given case, man. I am in a given case, I am submitting. So, my lord can do whatever, but what about the facts here? What about the procedure they have adopted? My response submission is one, the state has formulated a principle of selection. They cannot deviate from that and go for a separate selection. It was open for them to go for a selection according to the merit only. If there could have been, yes, or will hold a central selection and the merit will put to XYZ district because there is no bar for them to send me if I don't want to join in Palandi. Veterans there. I have no choice. But once they have given me a choice, yes, you say in which district you will prefer. And I have given the preference number 1 is Kalhandi. Now this, as per their procedure, selection has to be confined to the Kalhandi only. That is my submission. And that is why the Honorable Single Judge has also proceeded. So now, my lord, with this prayer, in the Annexure 6 to that list was the list they have prepared. They have given a heading, preferred allotted candidates. If my lord will permit me, I will take Annexure 6 is not there in the writ petition, it is there. Page 62. That was published in the website. I have downloaded and filed it. So it is a voluminous one, my lord. Selected pages are filed. Extract. Page 62 in the writ petition, WPC 978. If my lord, it will convenient, my lord, I have got the copies.
yes. What is there?
This is the writ petition copy, if my lord wants.
What is there?
Yes, this is there, my lord. This Annexure 6 is there. That they have not filed for convenience, I am giving it to my lord. Only one page, my lord. Annexure, this is Annexure 6, my lord. And you see, this is draft result sheet of junior teacher. This they have prepared. That is page 3. First serial number, application number, roll number, category 1, 2. This I have given 2. Art, science, language. Now, district allotted. They have given. It is not preference district. They have allotted it. Ganjam, Korapur, Jajpur. As per that, probably this is on mark because marks have not been published, so I cannot say. But probably this is on mark. They have allotted the candidates, irrespective of the preference, whatever it is given. But this is the violation of rule. The procedure clause 8.3. That I want to submit. This was the objection before the Honorable Single Judge. At that juncture, my lord, the Honorable Court, when they were processing for the verification of document, because after rule 8.3, para 8.3, the next stage is the verification under rule para 8.4. So 8.4 notification they have given. They have fixed a date. At that juncture, when we found that yes, this is a wrong list and this is not in consonance with rule para 8.3, so we came to this Honorable Court. And this Honorable Court, the Honorable Single Judge, has passed an interim order in presence of the Learned Advocate General that yes, you may proceed that 19.124 the interim order passed because it was on 20th. They said yes, you can go for verification. That will no final date. That was the order interim order. And thereafter, affidavit, everything was filed and finally that was disposed of. The Honorable Court has taken note of this particular aspect. The Honorable Court has also gone to the selection and the procedure they have adopted in the pages 8.1, 8.2, 8.3 and 8.3. Honorable Court accepted our submission, what I am submitting, that yes, there is a deviation of 8.3. It is not a list of preference. It is a list on merit. Maybe merit because merit was not published at the time, but it's not as per our preference. In course of hearing, we have also filed document to show. Because in one end, the Honorable Court has said that no further proceeding, but they have produced, the state has produced, segregated the names from this Annexure C and placed it to the court in a sealed cover that this is our district-wise list. Only to cover up their own mistake, I would say, my lord. To 8.3, they say, as per 8.3, we have prepared a list district-wise, so this is the list. That was not. But in certain district, how could you get out what? Because this is in sealed cover. But in certain districts like Kalahandi, Sambalpur, Balasore, Gajpati, they have published it. What was in the sealed cover before this Honorable Court? But they have published it on their own, I don't know, in the website. So we immediately got it uploaded and found that the person so named in that list also have not referred to that particular district. We have filed the document along with the regender. I filed the documents at Annexure C by series. There to demonstrate the fact that the persons in the Annexure C, the impugn order, you have allotted, they have not referred to this particular district. One district example, I can also right now I'll show from the record. That less number of posts advertised is the Gajpati. Only 4 seats in category 1, 6 seats in category 2. I have demonstrated also, I have filed it to the court, it is on record. None of the candidates who have applied for Gajpati, they have 87 candidates have applied for Gajpati. But none of the candidates have been selected against those vacant posts. Outsiders have come. Those have not preferred. Outside in the sense, those have not given first preference seat to the post to the Gajpati. They have been soon selected against that.
Suppose there are 2 districts.
Yes.
In the state, for which no first preference is given by anyone. Then what will happen?
Well, I think this, yes, that will be a point. But here in this case,
we are considering the procedure. We are considering the decision. We are considering.
Then it takes care of. Clause 8.3 takes care of that.
What?
It says, after exhausting all candidates having first preferences, subsequent preferences will be considered. It has takes care of. Not that there is a vacuum. Suppose for Gajpati there are only 4 posts. People may think that no, I will not prefer it because I have less chance to succeed. So where there are large number of vacancies, I will apply for. But since all the candidates are directed to give 30 preferences, there is no case, as my lord has suggested, there is no case that one district will go with unrepresented. No. Because every candidate has to give 30 preferences. Maybe all the candidates have 30 preferences Gajpati.
No, are they compelled to give 30%?
Yes, ma'am. That is the format, ma'am. I have given the application form in that advertisement. Kindly see. They are compelled. That is kindly see on page 40. That in that petition I have given the application one 4 application form I have given. That is the printed. That is the requirement. That is no dispute over that. Knowledge that application will be rejected, ma'am. Kindly see. Sorry. One of such application, page 40 of the writ petition I have handed over to me. It says, as my Senior Minister Advocate General has also shown it to from my application. This is a printed application form. This is issued by the OSEPA and we have to fill. Every candidate has to give it.
No, how do you say?
Pardon me?
How do you say that every candidate has to give 30%?
That is the prescribed form. That is the online application form, and I have get this. Everybody has bound to give. That is the requirement.
Where is the requirement that those are mandatory? Is there anything?
That is mandatory under the.
It can be mandatory.
Yes,
but let us understand.
That is mandatory. Well, that is not.
The form is only
I just because that is not the question for that is there, man.
the form only says district preference for joining.
I know. I will come to this.
District preference for joining.
Fine. I will answer to this after verifying because I
This, again, this district preference is not for selection. This is district preference for joining.
yes, man. Yes.
So if you
Because
go
this is
by
a district cadre post. This is admittedly this is a district cadre post, and we have to prefer accordingly 30 districts. So first that you give your first preference. Then when they will allot me.
All right, but how do you say that all the 30 they were to be filled up?
So there is no asterisk to say that it is mandatory field to be supplied.
No, my lord, it is mandatory because immediately I cannot have to take a stop because this part was not there. If after lunch also I can answer it because my clients are there.
No,
But
normally
Plus
online
59.
application forms
that
they put asterisk or red mark saying that they are mandatory field to be supplied or filled up.
yes, ma'am. But I'll just come after lunch. I will clarify this aspect of the matter. My lord, I am just holding it.
I will continue. You will continue after lunch.
If my lord, but this particular point, my lord, not that way. I don't want that, but because this is a question immediately.
Okay,
I know.
we are not hearing.
My lord,
Yes.
I should satisfy my lord.
Yes.
Because immediately I have to read it. I will not waste my lord's time here. I will launch in the immediate
Even
lunch.
substance is
It is.
irrespective of merit. Wherever your
Now,
position.
mine. I respond submission is. It is not the case that only merit is the criteria. Then many meritorious candidates are also there who have not applied. So now the selection is between the candidates those have applied for. And the process has been codified to all the candidates. So since the examination is there, this is a centrally selection. Because for each district, earlier they are holding the selection for district. But there was some allegation in some districts, some manipulation and other thing. So now they are holding the examination centrally. But therefore they have put 8-1 first. Thereafter 8-2. 8-1 says you should segregate the application from district wise. In the first preference. That is why I am giving emphasis on that. Once you have segregated the application form, now you get the marks on the selection. Whoever he has applied, the first preference district, the marks will be fitted into that selection. And the selection will be district wise. So that is the purpose. Because this is a district cadre post. So therefore my response submission, merely because there is a selection test, whoever he is there in the secured the highest mark, he will get an appointment. That is not there. Had it been so, para 8-3 should not have been incorporated to the selection. So once they have knowingly entered a provision into the procedure, so now the state cannot go back and say, no, I will not adhere to that. That is not permissible, my dispute submission is. And moreover, the judgments, as laid down by my notes, is if a thing is to be done in a particular manner, it has to be done in that way. And the private opposite parties now, those who are coming that we have secured higher marks, so we have to give appointment, not this person. So that is also not a case. Because they could have, because this resolution was open for them to challenge. They choose not to challenge. Now they cannot question that. That is my humble submission. Since 8-3 is a particular provision in the list, and that is also a stage after 8-1, 8-2, and 8-3 comes, so it has to be filled up as per the procedure laid down there. That is my humble submission, which has been accepted by my single judge in this case. And so far, this today, let's see what happened. What the Honorable Court has said, Honorable Single Judge has not entered into that, said that I should be given appointment or they should be denied appointment. I also conceived I was also having some homework. I found all these candidates securing higher mark will not be eliminated. Definitely they will not eliminate. Maybe it is a position, suppose he has secured, by chance he has secured good marks. This is a computer-based test, for chance he scored well. he has
By
preferred
chance, they scored well.
because these are these multiple choice questions. I have well, so we have also sometimes we are sitting in that examination. So whatever it may be, I'm not going to that.
Write the case objection to this.
No, I withdraw that.
No. When did he last sit for this examination? I want to know.
No.
Because when 100 he says I am sitting for the exams.
No, when I was
Our children are now sitting for those exams.
30-40 years. My lord. So now the question is, my lord, these points, the marks, whatever they see, they will not be eliminated as I have my homework rules. What will happen, my lord? If government has now allotted him to Cuttack, he may get an appointment in Balangir because of his past preference. But he will not be eliminated. Let them demonstrate. Nobody. Because today my senior has filed. I am obliged to him. I have filed it in Annexure C3 before the Honorable Single Judge, the discrepancy in the list. A person has applied for Gajapati. He has not been selected for Gajapati. All other persons, other than the person applied for Gajapati, only 10 posts, 87 candidates applied for 10 outsiders have come. The first preferred. Outside in this sense, those have not before passed. Now today, my senior has filed with a memo these two documents. He has did that work for me, I think. But today he has given the first list they have prepared. 21% for Navarampur district, and out of 21, serial number 10, 18 and 20 are the outsiders, not first preference. Their first preference was Mohiband, Keonjhar and Mohiband. 3% out of 21. So 21 candidates got the selection there. So they have given a revised list. As per my argument and as per the judgment of the single judge, they have prepared the list. They say 21 by taking the first preference in Navarampur. Almost the variation is very nominal. So not that all are eliminated. And I got my challenge is, though I have applied for both, now as fairly submitted by my senior Mr. Advocate General Milo. Initially, when they have issued the category 2 list, that page 3 of that memo today my senior has filed. They have stated in the category 2, my lord, out of 18 candidates, they have listed the first. What they have done, there are almost all are outsiders. On except one, this is for Malkangiri. Only 2% from, only one from Malkangiri. Serial number 1 is from Malkangiri. His first preference is Malkangiri, he got at serial number 1 because he has scored very high mark, 179 point something. Others were outsiders, other district participants. No, after revision, the last cutoff was 171.5. Now, they have revised it after post-judgment. So they come to conclusion, if all the first preference of Malkan district comes, my lord, again another 18 candidates will come. This first person who has applied for him continues to be at number 1, serial number 1, and others. And I came into the picture. My name found place at this AMIYA, he came into the selection. Because I have preferred Malkangiri as my second preference. As per my mark, I come into the selection along with others. So this is for the, so my responsibility, if they would file a further document, all other persons from Bhadra, Keonjhar, come into the Malkangiri, they might have been adjusted in some other district or in their respective first preference district. So my submission and the finding of the Honorable Single Judge is also that. Honorable Single Judge has not scrubbed everything. What does it say? The Honorable Court has said, you proceed with...
Sir, the only adverse effect of the result would be that there may be circumstances where a candidate scoring 165 will not get any place, whereas a person who has secured 140, he will get some position somewhere.
Well, maybe the position like that because of the stipulation in the selection. That is the process because of the selection procedure adopted by the government. And that is why I have read the first, I start with my argument taking note of that Shiksha Sahak advertisement. The same situation, government would have rectified from that, knowing fully well that is a setback in the first writ petition by Honorable Single Judge which has not been challenged with regard to Shiksha Sahak. Same parameter provision. So if the government has thought of the same thing, they could not repeat it here. So
the decision of learned single judge will not bind scores.
I cannot say so. Why shall I say?
You will have to say.
Yes. But my responsible submission is, in a given fact, whatever the challenge before the Honorable Single Judge, there is no illegality or infirmity in the order of the Honorable Single Judge. That much I can say, because the fact before the Honorable Court was that yes, the select list has to be prepared as per clause 8.3 strictly. Since there is a deviation and no cogent reply was given to this Honorable Court by the Honorable Single Judge, the Single Judge has proceeded as per the procedure and came to the conclusion. Now, another only one more. That the argument has been advanced with regard to non-gender of party. As my lord of the other day also, when my senior Minister Advocate General or my senior Mr. Rautrai was blessing that paragraph, my lord had confronted them with the particular finding of the Honorable Single Judge. Has taken note of so whether they are necessary. Only two more. I have given the judgments there also. Only two more judgments I want to give, my lord. For this simple reason, my lord, my responsible submission is, even if they are not made parties, let us assume they are the necessary party. They are not necessary party because it was a draft list. And draft list never gives any right. A list only give a right only at the stage of clause 8.6. When you have a glance to clause 8.6, that is the next stage. Thereafter, I will come to this judgment. Sorry, clause 8.5. Clause 8.5 only can give that if you will go to the scheme. Page 79. Kindly see. After that document verification 8.4, the next stage is preparation of district-wise provisional merit list and that is, there is a stage. Cause of action for them, at best, they can say that we are the affected party, accrued right, only there. Can you see? Provisional merit list. After verification, somebody may be discarded because some wrong certificate, wrong facts, he may be eliminated. So now 8.5. Provisional merit list will be prepared after document verification of the candidate placed in the draft merit list. Then objection will be invited from the candidates who are placed in the provisional merit list and a rejection list. There will be two lists at that stage. One is the select list, one is the rejection list. If suppose I am rejected, so reason will be given to me. So I will have a right to object to that list. No, why you have done it? Why somebody X name has been entered? That is the stage matter. But I came at the clause 8.3, and this says the provisional merit list will be approved by the competent authority at respective district after verification. This list is to be done as per the district list because the district is the cadre matter. The district cadre authority will have an approval to that list, inviting objection from candidate within specified time period as mentioned in the calendar of activity.
Inviting objections from?
Pardon me?
Inviting objections from
the candidates. Reject.
Candidates selected or even not selected?
Two lists will be there, selected and rejected. And at that juncture, objection is sought. Definitely objection, because they were rejected, they will
so according to you could have objected also?
No, I could not. That is after verification. Only the selected candidates. This is probably I'm not clear.
No, let us see the resolution first.
Page 79. Page 79.
He said that only those who were selected could have objected. Where is that?
My lord, clause 8.4, number 8.5. 79, my lord. That resolution I was reading 8.3, my lord. Thereafter 8.4 is document verification. Document verification. After document verification, that is the stage. Preparation of district-wise provisional merit list and approval. That is the heading, man. Provisional merit list will be prepared after document verification of the candidate placed in the draft merit list. Then objection will be invited from the candidate who are placed in the provisional list.
So this is not this
stage is
objection. No. This objection was to be made only by the candidates who were placed either in the provisional merit list and the rejection list, not otherwise.
Draft list.
All right.
We have not reached there. Our name is not there.
That is only persons whose name found place in the draft
list.
Yeah.
My name is not there in the draft list.
So you could not have.
Verification was undertaken. In the verification, if somebody is disqualified, then he will be put under rejection. If he is qualified, then he will be put under merit list. So that is the
stage. So, but I have come to this honorable court at the draft merit list, 8.3 man. I came 8.3 and 8.4 in between. I came. This draft list doesn't bear our name. So we came to the honorable court because that is in violation of 8.3. That is my sum and substance of my lord. So therefore, my lord, the necessary parties, they are saying, now this list under 8.3, suppose somebody's name is there, he didn't get any right, verification is there, or thereafter only a list will be published, there you will have a right. Some right will come. So then, now I want to place a judgment. But even if my response submission, here the procedure I am telling you, the procedure they have adopted is a faulty procedure. It is in violation of their own procedure. That is stage I have come to this honorable court. I am not challenging anybody's. My inclusion is not there. I have come, there almost a draft list. It's not fine. Thereafter verification and other things are there at that stage. So at that stage, these persons, those names found place, there is no name, roll numbers found place in that draft list, have not accrued any right. My response submission is that. Even if considering for a moment there is a right, at first they can be proper parties. They are not the necessary part. This is the second. The third, my lord, even if let us there the proper parties, what best argument they could have advanced at that stage? Because even if now, because normal course, my lord,
More than what could have been advanced by the state itself.
much of that.
This is what you are saying.
Yes, sir. But and whatever now argument, they are also arguing in the same line. So now the issue boils down to one point, whether this preparation of draft list is in accordance with Rule 8.3, Para 8.3 or not. The Honorable Single Judge has come to a conclusion it is not. So therefore, the Honorable Single Judge has directed you start from that stage. The Honorable Court has not scrapped anything. He says you start that in that stage. Prepare the list, everybody will. There is no problem. It will be in accordance with your own guidelines. So once you have framed a guideline, you proceed according to that guideline. So no prejudice to any other persons. Because there is no challenge to that clause 8.3. The judgments I am relying upon, my lord, with that, because when the this non-gender party is not FATA, they are not to be given opportunity of hearing. That is AR 1974 Supreme Court, page 1755. Other one I have to rely upon, but that Para 20 I rely upon.
Yes, when the policy itself is under challenge.
The other one is, there is a futile writ. The 2015 volume 8 SCC 519.
Futile, right?
Futile writ, yes, ma'am.
Means?
Yes. This useless formalities and other things.
All depends between.
Relying upon that judgment of Honorable Supreme Court of RC Tobacco, means that has been referred to there. I'm just giving 2 copies of that.
They could not have used this expression, futile writ.
Madam?
Futile writ expression could not have been there.
No, my lord, that they says that useless formality. So
Useless formality.
Useless formality. By relying upon the another 2005 Supreme Court 4233, that is been referred to there. I'm just giving the copies. One paragraph is also quoted there.
Yes. 2005
Supreme Court 4203. That has been referred to by my lord in 2015.
Yes.
Well, so my response submission is to sum up my argument, my lord.
Yes.
Since the government has issued a guideline, they have to strictly follow the guideline, and the entire process has to proceed in accordance with the same guideline. Since there is a deviation, and I have demonstrated through records to the Honorable Court that yes, there is a deviation, it has not been followed, and therefore, and the Honorable Court has taken note of each of the statements. The Honorable Single Judge is very exhaustive one, I would say, Manu, and it has taken all the points raised by parties and reached all the points. Therefore, this needs no reference of the I am obliged to my friend, what question put to me, that application form, he has downloaded my friend. That is compulsory. That's compulsory. It is there, man. Rates, you have to bound to give 30%. Your application will be rejected. All समस्त 30টা দাও
will make a printout.
I will get a printout and I'll finally
No, not required.
my. So that is
They will take note of.
obliged.
Anything?
One line that on behalf of well, the judgment which was cited by Justice Shriya, that single judgment, my left hand cited. In fact, that is on the basis of a resolution which has been superseded by the subsequent resolutions. Must be kindly look to that. And that was a judgment where matter was remitted back. People also see that that has been remitted back. And that judgment has nothing to do with the present facts and circumstances. And so far, our entire case is 8-2, and the notice has been issued under 8-2, and 8-2 has not been dealt with by the announcement. On the merit, was already said, I have nothing to add. And so far, the judgment which was cited, that is a case where the policy was challenged. Here, the policy has not been challenged. Here, he has challenged the draft merit list.
No, his submission is that nothing more could have been argued by the private persons than what had already been argued by the states.
Had we been implicated as party, we could have said, we could have at least bring to the notice of the Honorable Court that we are the meritorious candidate, we have exercised our right of preference, and we have been selected in terms of 8-2, and 8-2 could have been taken into consideration by the Honorable Single Judge.
But the doctrine of, the theory of unfair trial with a fair appeal, 86 Supreme Court, Institute of Chartered Accountants. Honorable Supreme Court says that in case of this category, if you are not hearing a necessary party and subsequently pleading party in the appellate stage or hearing them, that would amount to an unfair trial with a fair appeal. The clear answer to that is 86 Supreme Court, and I give that judgment.
And the Priyamada Das case judgment that division bench also referred to, there is a case of they are qualified in the written test and a provisional list was prepared for the purpose of ASST test. That was the subject matter of challenge. Relying on Kulwant Singh judgment, Para 25 will also be looked to that. The coordinate bench have clearly said that they have a right, whatever right, semblance of right, that they must defend it. They have a right to protect it. Therefore, they have the right to that. One thing in the
Can I just put a request? Just a small request. Another matter with regard to virus is posted today 2 p.m. But this matter has taken our night candle million. Yesterday we all were completely over this matter.
State is other side, of course, and let's keep it to Sonali.
It may be difficult for you to get another date.
That cannot be considered.
Yes.
Light up for 2 weeks.
Okay.
Yeah.